Yeah.
There it goes. Excellent. Okay, welcome everyone. Let's go ahead and get started. We'll start with the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, so we are small in size today. Kevin Daly and Gina Hurst have been excused for other commitments, and Commissioner Helgeson has resigned her position. She had some other commitments that conflicted with her planning commission, and so I want to take the opportunity. I'm technically up for the prayer thought, but before I give that, I really want to express my appreciation to her. I thought that she provided very valuable insight, and she will be missed.
Hear, hear.
All right, moving on to prayer thought. You guys know that affordable housing is something that is near and dear to my heart, and I happened to notice an article in the Salt Lake Tribune yesterday that indicated that Utah's ongoing housing affordability crunch isn't just squeezing renters and first-time home buyers, but it's also having impact on existing homeowners who are still paying off their mortgage. According to this article, and this is based on a neighborhood.com, neighbors.com, as many as half of Salt Lake City homeowners that are still making house payments, they would struggle to qualify for a bank loan to buy their exact home where they live now, or that they wouldn't qualify at all. And when you look at that Salt Lake, they also had a graph that showed that for Bountiful, not Centerville, but Bountiful, our close neighbor, 36.3% of people in Bountiful would struggle to buy their house now, or wouldn't qualify to buy their house now. So it was bestneighborhood.com is where they're finding these statistics. And on a national basis, that's about 27%. So in Utah, we're significantly higher in terms of housing affordability. And that's driven a lot by the fact that since 1992, we've seen an annual average increase of 5.7% rise in the cost of homeownership. And what that means, sort of taking that to a more macro level, is that the monthly mortgage payments on a median priced home in Utah have spiked, and they've risen by 56%. So in 2013, your average house, or your median house payment price would be $1,100, roughly $1,100 a month, and that's now $1,800 a month for a median price. So anyway, as we as planners are continuing to think about this, I think that we need to keep our eye on growth trends and housing affordability, and look as we're planning, not just for our current residents who are incredibly important, but as planners, we need to be looking down the road at how that's going to impact our city long term. So I think that these are important statistics and important data to keep our eye on.
Well, and Shaylin, even related to that, sort of, I hope it's okay if I just
please
cut
do
in real quick. I was talking to a friend of mine who is an empty nester who wants to downsize, but she literally said, I couldn't afford a house, a smaller house today, a new smaller house today than it's cheaper for me to stay in my house, my big, huge house that I don't need to fill, that I don't need to heat or cool, than it is to get a smaller house, a smaller, newer house.
It's really crazy when you think about it. I mean, I've thought about that sometimes myself, right? Ooh, would I even buy my home now? Because, I mean, I bought it right at the peak of the 2005 period where I thought it was the worst time to buy, right?
Right.
Retrospectively, and now my house is still worth more than when I bought it. So, yeah, it's a little nutty. I know that the Utah legislature, if you guys are tracking that, Utah legislature is starting to look at this issue. There's a new bill that they're passing to try to encourage municipalities to look at affordable housing issues. Senate Bill 34. I haven't looked at it in detail, but I know that that's certainly an issue that they're taking up. I was listening to Tim Hawks, our representative in this area, or at least my representative, who was talking to a group of, I want to say that it was the League of Women Voters. Maybe it was something different. But one thing he raised that I hadn't even thought of, and I'm always thinking about it from a housing perspective in terms of, can people afford to, our kids be able to afford to buy these homes long term if rates continue to escalate the way that they are. And he was looking at it from an entirely different issue. He was looking at it from a water issue, right? We live in a desert and we're running into water problems. And he says, you know, if we build an apartment building, that from a water usage standpoint, if you put, you know, a bunch of apartment housing, that's not going to create a big water crunch because that water is recycled from a culinary standpoint. Where you're really going to see a housing crunch is if we continue to have a lot of single family homes with large yards and we irrigate those yards, and that's going to create a longer term water impact. So I think that there are definitely a lot of ways to be looking at growth from, you know, housing affordability and from water sustainability impacts. So,
Right.
anyway, that is my thoughts for the day. We're going to turn to the first item on our agenda, which is a discussion of subdivision ordinance updates. We're looking at Chapter 3. So I'll go ahead and turn the time over to Lisa Romney.
Great, thank you very much, and thank you for agreeing to have the meeting so we can go over this. This is a rather lengthy chapter regarding administrative provisions, so it's just kind of setting some general parameters for all types of subdivision applications and vested rights and other things like that. So what I thought maybe we could just go page by page, or, you know, see what comments you have, if any. And then after we've gone through the entire section, I'd like to go back and revisit the noticing, because I've spent a lot of time since putting this in the packet on the noticing provisions and trying to make sure that we're in compliance with the state statutes and things like that. But I would like to get the Planning Commission's and staff's input on what kind of noticing do we want to provide for subdivisions. But just to make sure we get through the chapter, I'd like to go through the chapter and any comments you have on it. So maybe I will just kind of talk about each page and what's on there. But essentially, as I said, in just section 040, we're talking about just basic plat requirements. Page 2, we talk about exemptions to the subdivision plat process. Another exemption might be our small subdivisions, but I didn't put that here because technically they're not exempt from the plat. They have a reduced or expedited procedure. And then just some general development requirements. So these are all the things that we're going to use if, you know, usually for enforcement or interpretation. But and then we have the application requirements. I did try to add in, as we did with our zoning code, that we're emphasizing the required electronic. We still get paper applications, but I've put in here that it's mandatory now that they provide us an electronic copy of everything they submit, because that's the, you know, generally we're emailing it back and forth and we're posting it online. So hopefully that'll make it easier for staff if people comply with that.
I have a question about this. Can I jump in right now, or do you want to go through the whole thing?
Yeah, no, any.
Okay,
comments?
so I know we talked one time to making this accessible, just more accessible to people to understand what their requirements are or what the steps are that they need to take to fulfill an application or whatever. How different is this than what it was previously, or is there? I know you said that there's a specific place that gives them all of the steps that they need to take to make sure that their application is complete.
Yes, and I haven't looked at the current one recently, but I don't think we changed a lot. Again, this isn't talking about what's required for conceptual or what's required for preliminary. It's just saying,
just the outline.
Here's the procedure for
Yeah.
any kind of application. We're going to take it in and remit it. We're going to get the fees. We're going to review it for completeness, which is an important step because they don't obtain vested rights until it's actually complete. So a lot of times people just try to pay their fee, but they don't submit anything, or they submit their application, but they don't pay the fee.
Yeah.
You know, to try and get in under the wire. But again, you have to have a completed application. So I think, yeah, we haven't changed a lot of this, but I do recall that discussion of trying to make it easier on applicants to comply with our ordinances and know what to submit. We do currently have some great graphics that community development has prepared for each type of application. It's a tri-fold, and it tells you what you need to do.
Good, great.
But obviously, with this subdivision rewrite, we will have a lot of work on revising our forms and revising those handouts, because we are changing some of the requirements at each step. So, but that will be after the ordinance.
Lisa, just real quick, so the commission knows, we currently are moving to an online application system.
Okay.
And the consultant is working with Cassie right now to begin the process of some types of applications and start doing the test procedures. In short, it will take them through what they have to submit.
Perfect.
And they have to say, upload it, yes.
Yeah.
There's a step. Upload this, yes, or sign this.
That's
And so
fantastic.
it will allow them to go through online to know that they've got a completed application. Now, it's not forcing everybody to go to online. They can still come in with the packet, but the packet does the same thing.
Okay, fantastic.
But
Thank you.
I'm excited about it too, because it actually makes them click. So you can't submit the application if you don't say, yes, I've submitted those 5 things. Like if they leave one blank, they can't click submit.
Right.
So
Perfect.
it's going to help. But as Corey said, we're not forcing people at this time to use that. But I think people will like it. And the other functionality that the software has is that they can get online and check the status of their own application. So the idea is that they won't be calling
Fantastic.
staff all the time saying, where is it? We'll see how much that works. They'll probably still call, but it does allow them, if we still have that, to log in and see where their application is.
Great, thank you.
So,
One question on that. That's fantastic. I think that's good news. Are there any other cities that's using the same platform that you guys are?
Yes, Summit County Health uses a platform for all their permits. Kaysville uses it for both development applications now and their business licensing. We've already built the business license module for this year's renewals, and now we're doing the development. I do think there's 2 other jurisdictions that are using the system. It's called Civic Review.
Okay.
So if you
Yeah.
go up online, you can see their product, but it's called Civic Review.
Cool.
Great,
yeah,
thanks.
we're excited about that. It also allows for internal communication where we can keep tabs online.
Great.
So, okay, so I'm just on page 4, and again, yeah, if you have any comments on just,
Do you want us to jump in, or do
Yes.
you want to go through it and then go back and go page by page?
no, jump in. So if you have any comments, I'm just
On pages, okay.
facilitating that.
Got it. I have a couple of comments
Okay,
on
great.
these. And some of, very few are actually substantive, but some of them are more just either grammatical or stylistic. So I noticed in 15, so this is on page 1, in 1503020, there's no Oxford comma, but in other places there are Oxford commas to separate submitted, reviewed, and acted upon. Can we just make those
yep.
consistent? I think that it seems like we prefer, based
The
on what I
comma.
saw, the Oxford comma, but that one was missing.
I vote for the Oxford always.
I'm an Oxford comma fan, but I'm old school.
Same.
This is one just stylistic comment. In definitions, how we list at the end of that sentence CMC 15.02, and then we put in parentheses definitions. We sort of sporadically will include parentheticals after some, but not others. I don't really have any major heartburn with doing that. I just noticed that in some places we do it, and in some places we don't.
Okay, well,
Is there
maybe let
kind
me
of a-
know. When we did the zoning ordinance, I prepared a sort of a citation format. So if you're citing a section, here's how it should go, and if you're citing a chapter, so this is a chapter example.
Okay.
Then you put, if it's a chapter, then you
Oh.
put in parentheses what chapter it is. If it's a title, there's a different citation. So,
I didn't
yeah,
pick up
let me
on that.
know if
Okay.
there's similar citations, but trying to be consistent with that.
Perfect,
I
okay.
will just make note of that.
That actually may exactly explain the difference.
Yeah, if
since I
it's
just didn't pick
sections,
up
so
on that.
again, sometimes I'll refer to CMC 1503.010, But that's, if it's
section.
referring to the actual section, then I just say this section. And I'm not gonna repeat the citation, but if it's referring to another section, and on sections, I don't put
Yeah.
what it is.
Okay, fair enough. That sounds like a very consistent way of doing it. That makes sense. Okay, on page 2, did anybody else have any comments on page 1? Page 2, so under subsection C of 1503.050. So it seems to me like there's the comma placement in this one is awkward. So I would have it read, the boundaries of any lot or parcel, take out the comma, created after the effective date of this title, comma, which
Okay,
is,
wait, sorry, where
so
are
I'm
you?
on 1503.050, so agricultural exemptions, subparagraph C.
Oh, C, okay.
Yep, record
sorry.
of survey required. So I think what this is trying to say is the boundaries of any lot or parcel, take out the comma, created after the effective date of this title, comma, which is exempt from subdivision requirements as provided in this section, comma, shall be graphically. Is that,
Yep,
that's how, the comma after parcel seems awkward to me.
yes, I agree.
Okay.
That's a good
And then
catch.
when we're talking about the boundaries, and I don't know if, honestly, if the answer to this question matters, but I'm gonna ask it anyway. The boundaries of any lot or parcel created after the effective date of this title, the original effective date, the amended effective date, or does it matter? I don't know that it matters, as I thought about it after I flagged it, but,
Yes, and,
because anything
actually,
under-
that is language taken out of the state code, but added in here. And that will always be an interesting question, because if, for instance, we always have to look at the ordinances in place at the time, in my opinion. So, yeah,
Right.
this code was recodified in 2016. So if it was prior to that, we
It
would
would be
look at our
under the old one,
2003
yeah.
code.
That's what I was thinking too. I flagged it and then wrote to myself, does it even matter what the answer is? So,
Well, and we could just say the boundaries of any lot or parcel which is exempt from the subdivision requirements. Well, yeah, created after. Yeah, that is, let me think about that. I might even take that out. Because you don't
is
need it.
redundant.
Yeah, okay.
Yeah, okay. All right, here is a question for you. In 1503.060, the development requirement, subsection A, in the second sentence of this, it talks about, I'm looking now at the very last line of this. It's talking about the various size and design of lots, blah, blah, blah. They shall all conform to the land uses shown in the standards established. You list the general plan, the zoning code, and other applicable ordinances. So you list those 3 things in this subsection. But it caught my eye that if you look back one page, under 1503.040, the subdivision plat required, we're listing a whole bunch of other things in that section. So in addition to the general plan and the zoning code, we're listing the master street plan, and we're listing the specific title, and we're also calling out state law and city ordinance. Is there a reason why those aren't consistent? Or do we want to make them consistent, or is that a purposeful difference there?
I don't think so. I think this second one was just trying to reach back to the general plan, but then also saying, well, but there's other items. So I can check that and see if we want to be consistent.
Only if I'm a lawyer and I'm looking at that ever trying to make an argument, I say, oh, well, they list it all out in subsection A, but not in 040, but not in
Yeah,
060.
that's a good
And
point.
anyway, it was just a thought, and the same comment applied to subsection C of 060. So just to give that some consideration as to whether we want to be consistent just to avoid ambiguity, or if we're okay leaving it as is.
Okay. So be consistent with reference lists.
Yep. And I don't have preference as to either or. I think that they encompass all of it, but anyway, something to think about. On page 3, under 1503.070, subsection G, where it talks about the remedy of deficiencies. This is just a question for you. So right now, the ordinance is drafted to say that if the applicant fails to correct whatever deficiencies are identified, the city may deem the application withdrawn. And I was just wondering, under what circumstances would the city not deem it withdrawn if it had deficiencies? I'm not trying to suggest that the city shouldn't have discretion to do that. I'm just wondering, under what circumstances might the city say, it's okay, even though it's deficient?
I think oftentimes we're nicer than we legally
Okay.
need to be. So it is providing that flexibility. And I think maybe if Corey and Cassie want to weigh in on that, but just having first of all, we have to notify them of a deficiency. And, we could say in the letter, if you don't, then it will be deemed withdrawn. That would be their decision right there. But.
I was just curious.
Can I talked with Shayla, and I'm going to have to leave in about 5 minutes. So I'm wondering if it's possible is there anything that we need to vote on? There's nothing voting on this, right?
No.
Is it possible to go, can I make a motion to review the minutes really quickly?
Sure.
And then we can go back, if that's okay with
Yeah.
everyone?
I would
I'm
second
so
that,
sorry.
if anybody doesn't have any objections. That's a great idea.
Just
No,
because we
can
don't have a quorum, and usually I would just leave.
Oh, you know what, though?
Yeah,
We're not
we're
going to be
not
able
gonna
to
have a quorum.
approve the minutes.
That's what I'm
Well,
saying,
that's
if
what
we
she's
can
saying,
go
let's
right
go to
now.
the minutes.
Let's do them right now. Are you guys okay with that? Yep, let's do it. Okay, we're going to postpone discussion of the subdivision ordinance. We're going to go ahead and move right to item, whatever number it is. We're going to review the minutes for January 9th. Yep. We're doing this as normal, page by page. Let me know if you have any comments or changes. So page 1. Page 2. I actually had a minor change here with regard to paragraphs or line numbers 11 through 14. How do I do this the easiest way? So starting with line 13, I want it to read as follows. Proposed text amendment would increase the city's risk of legal challenge to its tattoo parlor prohibition, comma, should someone bring up the legality of, and then delete prohibiting tattoo parlors and insert allowing certain forms of tattooing but not others, period. And on line 20, as free express should be expression.
Also, any instance of micro space blading, it's one word, so if we wouldn't put microblading all together, it's on line 5, line 6, and then 26. I mean, multiple, you can just do a find and replace.
Any other comments on page 2? On page 3, I just had 2 very minor corrections or suggestions on line 1. Including that requirement would provide any additional, insert the word legal protection. And then with regards to, and I'll let Lisa speak to this one, but where it goes on to say, Ms. Romney pointed out that a tattoo license is required by the state to practice microblading and agreed with Chair Heyman that the proposed language would not likely add any. I think that she was talking about legal protection, so I would specify legal protection, if that's consistent, Lisa.
Yeah, I agree with that.
Okay. Any other comments on page 3? Page 4? Page 5? Page 6? Page 7? Page 8? Chair will entertain a motion.
Chair, I move that we accept the minutes as amended.
Second.
It's been moved and seconded. Any further discussion, debate? All those in favor?
Aye.
Any opposed? All right, great. Thanks, and you are excused.
I'm so sorry, guys.
No, I'm glad that you flagged me. I told Becky, I said, this will probably be like 20-minute meeting, like 30 at the max.
Sorry about that.
All right.
We wouldn't usually have people gone.
No, that's great.
Thanks.
I'm glad
So-
that you flagged me down.
So noting that we do not have a quorum, I suppose if you'd like to continue discussion, you can, but we can't, take any further action or direct staff.
We wouldn't be taking any further action anyway, because we're just giving you input, right? So I'm inclined to go ahead and finish up providing our input since we've reviewed them.
Okay.
And then if anybody feels strongly, we can bring it back to our other commissioners for further input, but
Okay, great.
thanks. Before we get started, I noticed that we have a troop of folks here, so I'd like to recognize them. Can you tell us who you are and where you're from?
We're Troop 1857 from Centerville, South State.
Excellent.
County Board.
Welcome, Troop 18. Say it again.
1857.
1857. Welcome. We're glad to have you here.
From the citizenship of the community very much.
Excellent. Well, very nice to have you guys here. Thanks.
Glad we have a really exciting agenda for
I
you.
know I feel so bad, guys. Normally we have much more exciting things to talk about than ordinance revisions.
Get
But
Lisa to talk to Lisa.
I mean, it's fascinating. It really is fascinating, Lisa. We like this stuff. Okay, let's go back to our ordinance revision. We're on page 4. So I'll turn it back over to you, Lisa.
Okay, so let's see, I think you were gonna say you had a, oh, yeah, the comment on G, that it says we
Oh,
may
this was
deem
3.
it withdrawn. Let's see, if the application is deemed withdrawn, the application and any associated fees shall be returned. So I think we have to take some action afterwards anyway. So, given our practice, I think, you know, we still have to follow up, so I'd leave it may.
I wasn't suggesting that we change it. I was just curious as to what circumstances we would say, oh, it's a deficiency, but that's
Yeah.
okay. That's all. I was just wondering.
Okay. So then page 4, any comments on that? And so that's the public hearing requirements, and then we get into the noticing requirements, and I can talk about those, but if, I'd like to come back to them, so unless you have some specific comments.
I did have one question, not a comment, but a question with regard to the emergency meetings. And I'm wondering what circumstances this would apply to as a practical matter to the planning commission. I'm not recommending that we change this language. I'm just curious as to when would an unforeseen circumstance come up that would be a requirement for the planning commission to consider something on an emergency basis?
Very, very rarely.
Yeah.
And in my opinion, emergency doesn't mean we forgot to put it on the agenda, or this applicant really needs it on the agenda. Emergency is, for instance, you know, some sort of windstorm or something that, and mainly that would be the council that would have to
Yeah.
get together. But yeah, it would be very rare. So that is just in there because this section is referring to the Open Meetings Act. And so just trying to remind people that this is one other kind of notice that you have to have.
I was just curious. Thank you. That was more for my edification than for anything else.
I can't really think of one either. It really.
On page 7,
One other question I
Oh,
had
yeah.
actually on the public noticing, and Lisa, you may cover this later, so if it is something you plan on covering later, let me know. In section 15030100, moving, it's kind of coming on to page 6 there, you list the different methods that we do public noticing and reference that those are in compliance with the Utah Open and Public Meetings Act. Are all 4 of those required by the act, or are any of those kind of added by the city's discretion and preference?
Yeah, and actually, these requirements are in 2 sections, not only the Open Meetings Act, but also in the Land Use Act. The Land Use Act requires it to be published on the city website, and then these other ones are in the state statute. So I think we do all, we don't do over and above, we just follow the
Just go to
state
the
statute.
Okay.
Yeah, yeah, the city website one is required under the land use code in, and then the other ones are required in the Open Meetings Act.
Okay, thank you.
hey Lisa, when we publish these, are they going to be published in this format? Or are they just going to be on an open online code? I notice only because there are a couple of hanging section symbols hanging at the end of some of these, which is not a big deal if this isn't the format that it's going to be published in.
We will be putting it on our municipal code online, so yes, the formatting will be different. We'll have to
Okay.
input it into HTML.
I assumed. On page 7, the word passersby jumped out at me just because it seems like a very awkward word. I mean, it's technically correct, but I'm wondering if it makes it slightly less awkward to make it singular rather than plural and just say give notice to a passerby. I don't have any strong feelings about this one.
And that one we get from state law.
Got
as
it.
well.
All right, we'll defer to state law and their awkward phrasing. Okay. Anything else? We'll come back to the notice issues, but do you want to?
Now, sometimes on state law, we can try to fix it and make it more modern language, but the problem with that is if the state law says passersby and we say pedestrians, then
Yeah.
there's going to be a conflict in interpretation, so I usually just try and stick with the language.
I completely agree.
Okay, it's page 8. Again, we're talking about our decision-making bodies and the decision-making standards. In the state statutes, they have tried to go to a new distinction between land use decisions and land use regulations. And land use decisions are administrative matters, and land use regulations are legislative matters. I just can't bring myself to go that direction because it doesn't make any sense to me. I still want to call it an administrative decision and a legislative. So I actually did not put that update in there because I just think it's confusing. It doesn't explain on its face what it is. When you say a land use decision, I still think that's a zoning
Yeah.
map
Yeah.
amendment.
As you listed the two, I thought it was going to be vice versa.
Yeah.
The one was going to be legislative.
So I'm just waiting to change the state statute, and we're still going to refer to administrative and legislative decisions.
I firmly agree.
Yeah. It's funny.
Okay, and then we get into our vested rights. Yeah, a lot of this is in our current state code. We've just updated it a little on the pending ordinance amendments. We've updated that a little, but what I put it in its own section number because I always have a hard time finding that. Now, I know we can just search the code online, but I just want a heading where I can find it, so.
2 grammatical comments on not the pending ordinance amendments, but the earlier one, the vested rights.
Okay.
So I'm at the top of page 10 under subsection C. Is it C comma CMC? Or is it just C without the comma? I'm too used to Blue Book citation, so that one stood out to me.
Okay,
So just think about that. In subsections E and F, everywhere else when we have an internal title, we follow it by a period. These are the only 2 places where I noticed that we did a semicolon after extent of a vested right and termination of a
yes.
vested right.
yes, so, yeah. And some of that, when the consultant drafted this, he went with colons, and so I've tried to change
fix
those
it.
all back, but I haven't caught them all, so, yes, thank you. Okay, and then page 11, administrative interpretations. This is just a similar clause to what we have in our zoning code. That's the other thing I've tried to do is trying to be consistent with what we have in the zoning code and the subdivision ordinance. They're both land use ordinances, but they're in separate sections of our code. But so this just provides the zoning administrator to make administrative interpretations of this section.
Lisa,
this chapter.
before you move to the next section here on page 12, in subparagraph E, this is the standards for making administrative interpretations on the top of page 12. The following standards shall apply to administrative interpretations. Here, I think we do need a colon
Okay.
to
Yeah.
be consistent with how we've done that throughout the rest of it.
That's good. And then amendments to this title. This is actually a new section. We didn't have a section on amending the subdivision ordinance. We usually just refer to the way we do it in the zoning code because it's a land use amendment, but I thought we might as well add that. And then administrative fees and appeals. So any other specific comments from the planning commission?
Yeah,
Okay, then maybe, oh, yeah.
As I was imagining the amendments to this title and that process going through, let's say that there was a subdivision change that was being considered by change by the city that Paul, or the mayor, not Paul, Clark, initiated a change in order to change something in the subdivision?
Change to the code?
That's correct.
Okay, so
So
an
one of these
ordinance amendment.
sections that we've been reviewing, for example, how does that affect current applications? Is there kind of a moratorium, or does it not really matter until the change comes into effect?
So if we're changing this code, anybody that has filed a completed application for whatever application they're applying for would continue under the old code. And then anybody that applies after we adopt the new code would have to comply with the new code. Now, there's the whole pending ordinance doctrine where you could arguably put something on hold because it says, hey, we're working on this change. So once we highlight that we're working on a change, the law recognizes that it's not really fair for people to try and hurry up and get in. So we can impose this ordinance that says you have to wait, but the state law restricts that time period to 6 months. We can't make someone wait more than 6 months. We've used the pending ordinance doctrine a few times, but it's not great. My preference is to, grant people their vested rights. If they're ready to go and they pay their fees, then they should get to go through under the old code. Now, when we readopted the entire zoning code, this is another thing to think about when you're recodifying an entire section. We usually say, we give it a post-effective date. Like, this is going to be in effect in a month from now. So you can read it, you can understand it, you can have time to deal with it. So, that's another way to deal with it, but obviously people can file under the old. But I think that happened with some things on Main Street. For instance, the Huffaker Dental, we were working on the ordinance, but they wanted to get in under the old code, so we allow something like that.
Thanks.
But all of those concepts, vested rights, pending ordinance doctrine, are in this chapter. So we're trying to address that, and not all of those concepts are addressed in the statutes, but they're addressed by case law. So we try to codify the case law as it stands.
Yeah.
Mm-hmm.
Thank you.
So I would like to go back to the noticing. As I mentioned, I've spent some time on this noticing because this new code requires more noticing than we provide right now. And so I want to make sure that we understand what we provide now and what we're recommending. So I've prepared this chart from my understanding of what we do right now. And I've had a bit of a discussion with Cassie, and I'm glad to find out that we provide a little bit more notice. But the way this chart is set out, it's like the zoning code. We had never done one for the subdivision ordinance, so this is new, but we have one for the zoning code applications. But on the left-hand side, the first column, you'll have the types of applications. And as we work through this, we may have more applications, like I didn't put boundary line adjustment, et cetera. We'll add those. But basically, we have text amendments. And instead of doing two charts, I just put the City Council and the Planning Commission on the same chart. So we have text amendments to this code. Then we have the conceptual subdivision, the preliminary subdivision, and the final subdivision. And then an amended subdivision, small subdivision, and vacating a street or easement, and then amendments to standards and specifications. So this chart includes all the statutory requirements. So that's where I started first. What does the state law require? And so on the little X's, or even up at the top, talking about what kind of notice is required, if there's an asterisk, that means it's state law and we don't have any choice. So that makes it really easy. Oh, I did put this on Novus if you wanted to. I put it on late today, and so you could put it up on the screen. Sorry. Anyway, so we don't have a lot of choices here, with what we have to provide. But I want to make a correction on the website notice, which is the 10-day to the Utah Public Notice website and the city website. And I think confirming with Cassie, we currently do provide, so put an X next to concept plan and preliminary plan and probably small subdivision. So we do post those on the Utah Public Notice website. So the items that would go to that state website and on our own website would be text amendments, conceptual plat, preliminary plat, small subdivision, and any street vacation. With those additions, I'm happy, because the way I was reading the ordinances, I was a little worried that the only notice that we gave for conceptual, preliminary, and final is this green, the dark green that says online, on-site posting, which is only 3 days. And so I didn't think that was quite enough. I wanted to propose that we give online notice, at least of conceptual. So.
I also always post on-site in the 10-day window and not the 3-day window.
Okay, good. All right. I like that too. So I was thinking the 3-day is a little aggressive. And if you'll see, so there's two green, there's a dark green and a light green, because there is a state statute that requires on-site posting for plat amendments and street vacations, and they require a 10-day notice. So that's why I would like to recommend that we actually go back to 10-day for everything, because then we know what it is. Now that puts a burden on staff and it puts a burden on the applicant, because it is going to take longer, but I think we will make fewer mistakes when we have the same note, because zoning is 10 days, subdivision's 10 days. It just makes it easier to provide the right noticing.
Do you feel the same for the 3-day buffer on your pink line, the applicant notice of meeting and staff report? Or
No,
you're just saying with the on-site?
No, just the on-site. So the dark green is a courtesy. The interesting thing is that state law does not actually address when or whether you need a public hearing for conceptual, preliminary, and final plat. They just say for final plat that, obviously somebody has to make the final decision. So you can see on the chart, we don't provide much there. We're providing, well, as I see in our code, the on-site, and I'm glad we're providing the website notice. I'd probably add the website notice to final plat at the council, but, so yeah, I mean, it would be a change, but from a practical standpoint, we're already doing the 10 days, I would kind of like that, but.
What do you guys think, Cassie, Corey?
I do all my noticing on the same day at the 10-day mark. So
no issues then if we just moved
Yeah.
it to 10 days?
Okay, I like that. Okay, 10
You
days.
just made Lisa very happy.
That's great.
Well, and just one comment on the signs. Normally, I wouldn't want us to have to do more than state law, and correct me if I'm wrong, Corey and Cassie, but don't you feel like that's maybe the most common way that people find out about meetings is the sign, little
I
thing
would say for
posted out?
subdivisions, yeah.
Yeah, because like, I bet 1% of the people find out from the Davis County Clipper that there's something going on, but most of the people see a sign.
You're going
up front.
high on 1%.
Yeah, I meant 1% of 1%.
Okay.
So.
No, I think the signs, for local development of a piece of land, the signs probably generate the most. Interest is relative. It gets the most communication.
Okay, and so is this accurate? Do you want to add the on-site to anything else? So we don't, let's see, final subdivision. Do you provide any kind of noticing for the final?
No.
Okay.
No,
You feel like you'd like
we've done the 2 hearings,
Yeah.
so we don't,
That's plenty.
at final, you're just checking that it's matching what
And I
the
think you're just
commission's
asking
approved.
for trouble if you do that again on the final meeting.
I agree.
It's more
Yeah.
effective to get those in.
Yeah, because the public perceives
Yes.
that when they're invited to a hearing, that that it's more of a vote system for them to weigh in on than an ordinance compliance review. So the final comes across to them as if they're still frustrated with something and they come in and talk on final, they're assuming that you have an ability to say no at final. And really at final, you're just saying, here, you've crossed the Ts and dotted the Is, and it sends a miscommunication to the public.
But it does look like we do post on site for when it goes to the council,
Yeah.
which
So you
doesn't
spare
totally
us
make
that
sense to
confusion,
me,
but-
yeah.
Right, because then that's the recommendation, and then the council has a hearing.
Which theirs is still an administrative decision,
Correct.
but, all right.
This has been the whole debate of when do we host hearings, and how much do we host hearings also. And that's, and if I correct me wrong, Lisa, we have to do one hearing at subdivision, but we do more than one hearing
Right.
by pattern and desire of the past councils and current council wanting to be more transparent.
And I would like to recommend that we eliminate the final plat going to the city council. I don't know if we'll be successful, but we could certainly simplify our chart if we keep all subdivision applications at the planning commission level, including, well, I don't know if we can do plat amendments. That may have to go to the council, but, we could simplify that. But
I'd support that. I don't know if the council would go for that, but I'd support that.
well, the one reason I think that they might is that most of the controversial projects are PDOs. And so they are going to be able to weigh in. Like if you think back on some of the more controversial subdivisions, I think that it was a PDO, so they would have had some input. But
I think that's also more difficult for the city council to make the distinction between when they're acting with their legislative hats on, which they do most of the time, versus administrative. And I could see how that could confuse the public again. So if I were the city council, I would actually welcome that change, because then people aren't yelling at me that they got up there and they told me about their concerns, and then I still have to approve it as an administrative matter.
You're putting them in a pickle. You're asking for liability here.
yeah, and I think that's why the Utah League of Cities and Towns, they recommend keeping administrative land use decisions at the planning commission level.
Yeah.
You also see that where some smaller communities, still the council is the appeal authority. And that is a problematic place when the council is looking at the record of the decision versus the public expectations.
So the newspaper notice, I'll just go across the top. The newspaper notice, the one in red, I would not add anything to that, and I think the statutes need to change because that's archaic. But, so we're only doing that for text amendments for the first public hearing and for street vacations.
Yeah, the goal of the Utah League of Cities and Towns several years back was to move to the technology and other based noticing, which they believed was more transparent than the back page of a newspaper. And there was always talk about eventually eliminating the newspaper notice, but traditions are hard to get rid of.
Yeah, that Davis County Clipper lobby's really hard to
Yeah, so
stop.
they haven't done it yet for everything, but they're trying to reduce the paper
makes
input.
You were very mean to the Clipper today.
No, I'm just kidding. I delivered for the Clippers, so they just didn't pay me enough.
So then the next one is affected entities. And so affected entities are a laundry list of defined as municipalities, special service districts, interlocal entities. In reviewing the definition today, it even said property owner, which I didn't realize was in there, but I don't know how we're going to notify property owner. But I would like, we've read this broadly on these required ones for text amendments, and I think we send notice to these affected entities, but we can read the statute more narrowly because it says an affected entity is one of these types of entities, one of 12, if, and only if, by definition, whatever we're doing will have a significant impact on the kinds of services or facilities they provide. So in Centerville, very rarely would we, I don't know that, a large, well, it would have to be a text amendment. What kind of text amendment might have an impact on sewer facilities? So we could look at reducing that, and then the other is if they notify us. So anybody can notify us that they want to be provided on a mailing list and then we would have to send them. But even the statute says they have to file with us every year if they want us to do that. So I think we could reduce our obligation. That's more at a staff level. It would still be in our code that, yeah, we have to if you meet this, but we could, I think, reduce that. Because I know I've talked with the city recorder, and she says these entities don't even know why we send it.
I'm sure that 99% of them end up in the mail of just the confused look on their face.
Right.
Why are you sending us?
I'd like to work on reducing that and not sending it out except in extreme, cases. But then we have to remember for that. Now, the other interesting thing, and Cassie did confirm that we send any subdivision that deals with multifamily or commercial or industrial development to affected entities. I could not find that in the statute, so I need to go back and find out if it was repealed or why do we have that in our existing code. But that might be another one that we can eliminate if it's no longer a state requirement. And then again, on the amended plat, we only have to notify affected entities that actually provide service. Now, sometimes we go ahead and provide it to everybody because we don't know, or it's easier to send it, but, so. And then we've already talked about on-site. We'll keep that as is, but make it 10 days. I may leave this other one, the on-site posting, because it's specifically talking about vacation of, an amendment, and it has a slightly different where it needs to be posted clause. So then the next three are for our mailed notice. So these are kinds of notices that we have to mail. We have to mail notice for street vacations to people that live on the street. We have to mail, this is a scary one. There's a provision in the state statute that talks about when we are doing a text amendment that we need to mail notice to any property owner whose land is directly affected by the land use ordinance change.
Which could be everyone?
Everyone?
We are not doing that. I can't imagine, I don't know. I hope that's a very high standard. Corey, I don't know if you've heard people chat about this, but I don't, it was an interesting comment. I know when we went to zoning map amendments, we have to give specific notice to the property owner who we're rezoning. Now, normally that's the applicant. But if we ever did a major city-initiated zone change, we have to send specific notice to that property owner and say, we're changing your property from this to this, and give them a copy of the code. So I don't know if this was adopted at that same time, saying, oh yeah, and you should notify property owners if...
I suspect it was couched in that whole discussion.
Yeah, or maybe by definition.
If it wasn't couched in that one, it was couched in the earlier township versus municipal annexation laws.
But I'm going to read that very broadly because we would be notifying the entire city of any subdivision ordinance amendment if we didn't.
Could we include just something on our city mailer, right? Oh, and by the way, in footnote, this is, because that gets mailed to everybody in the city.
Yeah, well, and it's interesting because...
Right. Not that anybody is going to care, but...
Yeah, there could be significant impacts with the subdivision ordinance, don't you think?
Yeah. I'm just thinking of the residential medium changes that we did. We would have had to mail something to every residential medium property owner in the city. And in some ways, I feel like they should know about those changes that are...
Because it could be, there could be significant...
Because people found out later after those amendments and people weren't happy about it. So in some way, it's going to be super burdensome for us. But in those specific cases, it's good to have that knowledge too. I don't know, and that's just the one I'm thinking of right now. I'm sure there are ones that would affect every property, and I feel like in those cases, you would have to do something like the utility bill or something.
Yeah.
Unfortunately, I doubt that the statute distinguishes between bills that residents like, or changes that residents likely would care about and changes that residents wouldn't, right?
Well,
I mean, I
something
can't-
that I'm just thinking of something like, because the RM zone is only like, you know, like 25%, like 15% in the city, where something that's like everything of the city, there's a difference.
Yeah. So I'd like to go over that statute with staff and make sure we're on the same page, because that one was a little bit of a surprise to me. And we need to figure out how to, you know, interpret that. But, and it is that we have to notify them 10 days before the public hearing. So it's not really after the fact, but at least they would be involved and know that, yeah, we were making changes and, you know, they could be involved. So that's an interesting one. And then the next one, I just put it on here because it deals with our standards and specifications. So if we are going to change our streets standards, you know, the width or the cross-section, then we have to send notice to anybody that told us they wanted to be notified. So as far as I don't know that we have a list of anybody that, you know, a lot of these are just compromises at the legislature where the private sector wants the noticing, or, you know, and the city says, well, if you tell us you want it, then we'll do it. So then the notice of a subsequent hearing, the reason we do a first public hearing and anything else is because the statutes often say you have to have at least one public hearing. And so what we've done in Centerville is just say, okay, well, the public hearing that we provide the statutory notice for is the first one, because that's easy to remember. So for the first planning commission zoning text amendment or subdivision amendment, we provide all that notice. But any additional public hearing, like let's say we table items, then we don't have to go through all of that again. We just have to put it on the Utah Public Notice website. So now that one I also didn't find specific statutory reference, so we could reduce that if you want, but so like if we table a public hearing, do you still send it to the Utah Public Notice website? We don't? Okay. Okay.
Yeah, just the first notice.
Then the last three are statutory again, so we have to notify every applicant of every meeting that their application is going to be on. And we have to notify them 3 days ahead of time, and we also have to give them every staff report. So, you know, if we have the original staff report, and then we have a follow-up staff report, so before every meeting, 3 days before, we have to notify every applicant and give them a copy of the staff report. So when they stand up here and say, you know, I haven't read the staff report, well, that's because they didn't take the opportunity to read it, because we're obligated to give it to them. And then the notice of the public meeting and the agenda, that's the Utah Open Meetings Act, 24 hours in advance, we give everybody notice of the meeting and the agenda and what's on it. That one's all statutory. And then after we make our decision, there's no specific time frame, but within a reasonable time, we are required to notify the applicant of the action that was taken. So we provide either an email or a written letter saying, here's your conditional use permit and here's the, you know, conditions. So there's a lot of notice that has to go out. And so when we're in some of these meetings and we talk about providing more notice, it's a little frustrating because we already have to provide a lot of notice, and I think it's best to have people understand where we're providing the notice and help them. For instance, on the Utah Public Notice website, the thing that's really nice about that is you can sign up for notifications, and they'll send you, you know, right to your own email box, all of our agendas or anything we post to that. So that's another nice one. Why I like it on the chart is because people can sign up for the notifications.
For any city that you want to follow.
Yeah.
Well, that's actually a really great tool, and I didn't know that I was able to do that, and I suspect most of the people in our city don't know that they can do that. I wonder if that would be a helpful thing to include in one of our city newsletters.
Yeah.
Hey, do you want to know what's going on in the city? You can sign up for this Utah Public Notice website. It's free, it's easy. Here's the email address, or here's the website where you go to enter in your information, and then people could be more up to date. I think that some education might be helpful on that.
Yeah, that's a great idea. I like that.
And probably some of these tidbits of information ought to be put out every so regular often to
Yeah.
keep people connected to it.
Like once a year or something, just remind people that they can do that. I think that's a city council driven thing, but Corey, you might want to raise that with them
Yeah,
at some
I
point.
think that-
I think
that's a
that
bad
would be
idea.
really helpful to keep people informed about what's going on in the city.
Okay. So I think I've received some good information, and can revise this for the way we're doing it, and then maybe come up with one that says, here's what's proposed. Because I think both the planning commission and the city council, as we move forward with this rewrite, will want to know what's the change, what are we doing differently? And so somehow if I can either get that on the same chart or have two different charts, I think that'll be helpful. But it's also helpful, I think, to just realize how much noticing we have to keep track of, and where we want to provide that notice. But that's what I like. If we are providing the Utah Public Notice website for conceptual and preliminary subdivision plats, people can just sign up for the list and they'll get notified of that. So is there any other noticing issues, or, if you'd like to add or delete from this list that doesn't have a statutory requirement? So you can see it's really just conceptual, preliminary, and final that we have any choice.
I don't have any additional comments or recommended changes. I just want to thank you for going through this process. I appreciate your careful thought and consideration and all of the work that you've put into this. Clearly, anybody who can come up with this type of a color-coded spreadsheet here is a woman of my own heart, Lisa. So
Good, well, thank you. It's been I've been meaning to do it for quite some time, because we have the zoning code one, but we didn't have
We actually
this
have one of these, Lisa, you prepared a while back.
With the
Can we use it?
subdivision?
Mhm.
Okay, well, I'll have to look at it, but I would like this one. I didn't do the color coding, so this one's helpful.
Yeah, I don't think the color coding's on it, but I think we have an older list
Okay,
that goes through it.
Excellent. Thank you so much, Lisa.
okay, you're welcome.
Next item on the agenda is, it's listed as a discussion about goals for 2019, which I didn't mean for this, since we have a small commission and now we don't even have a quorum. It wasn't meant to be let's come up with definitive goals. It was really more of a, let's start preliminarily thinking through some of the things that we may want to be thinking about as we're heading into our goal-making time period. We have a work session that's coming up with the city council. I think that that's a great opportunity for us to explore what issues are, burning importance to the city council so that we can address them. I do want to throw out there, I feel like lately that the planning commission and the city council have not been on the same page in terms of communication, which is, I think, is causing frustration both for us and for them. And I don't think that it's allowing us to be as effective as we otherwise could be. And so I wanted to just chat with you guys to see if, are you feeling the same way in terms of, do you feel like there's some tension between us and the city council in terms of goals or being on the same page? And I wanted just to sort of brainstorm for a minute what we might be able to do to improve that communication process.
Yeah, I don't know. That definitely is the case. I feel like that we see differently on a lot of issues, and I think it's caused a little bit of, we're not working in harmony very well. But we face such different, I don't know if incentives is the right word, but I think that a lot of this group comes from it from a little bit more of a professional standpoint, whether that's, we have engineers on here or attorneys or different people that look at it from a lot different lens than the city council. So what I guess I'm trying to say is, I don't know that we're gonna come to a great solution between the two, but yeah, I think that you're right. I think you've identified that there's a little bit of a rub there, and I don't know if that's by design, frankly, but.
Well, and I think, I mean, clearly, we operate in different spheres, and we should be operating independently. We should not be yes men for what the city council wants. Our obligation is to examine issues independently and make recommendations to the city council, whether we think that they're gonna approve them or not. So I view that responsibility as a really important part of us. But that being said, if we are on so totally different pages, that if they send something down for us to look at it and we pursue path, you know, on the left and we send it up to them and they are really over here on the right, that's not going to be helpful for anybody. And so I think that work sessions, probably more work sessions with the city council so that we can communicate with them and make sure we are on the same page.
Do you think that will solve it? I just imagine we had, I can remember 2 or was it 3 work sessions we had on the very issue of the table of uses and the Main Street. You know, I mean, if we were set that as a standard, it takes more than 3 work sessions to get good communication. Or SOL, we wouldn't be able to get anything done. And so, I don't know that I would think that more work sessions is the answer. Do you guys think?
I would think it would be. I would just think that extra communication is gonna benefit the relationship and benefit the process.
Yeah, I think, give that some thought, because it's funny that I put this on my goal, because this has never really been on my goals list, right? Communicate better with the city council, but I think that is something that we need to give some real hard consideration to, because, I've expressed, I was very frustrated when we, as I understood it, had directions to go look at the table of uses, right? We're gonna hang out the for sale sign. We're open for business here in Centerville, right? And we go through that whole process and it goes up to the city council and it meets a buzzsaw. That is frustrating. And we did the same thing with the Main Street design guidelines. And I would like for us to give some consideration, maybe more communication. I think that certainly is not gonna hurt. If we try to meet a little bit more with the city council. I also would encourage the city council to give us clear direction. I know that there are 5 city council members plus the mayor, right? And they're all on different pages, but the more clear and concise instructions and ideas that they can convey to us, I think the better we can do our job. Anyway.
And I don't know if this is speaking within scope of what we're trying to do or not, but last time we met, one of our citizens sat through the whole meeting. And then I felt like he recognized there was some rub between the two. And not that, and I think ultimately we're serving the citizens, hopefully we're serving the citizens, but I think he pled that somehow we resolve it so that he doesn't have to wait so long to accomplish some of the things he'd like to in his business or
Sure.
like to. And so honestly, afterwards, I've thought a lot about what he said and thought, we do need to get on the same page. We do need to work better together. But I just think additional communication or better communication is going to help.
We have very different goals. The city council is, I think, listening to what citizens want here and now, and I think that is part of our job as a planning commission, but we also are administrative. We're not elected. We don't have the same pressures that the city council faces, and our job is to look not just at what is going to make our city better tomorrow, but also, 20 years from now and 50 years from now. And so we look at things with a different perspective than the city council does, and frankly, a lot of the citizens do. And I appreciate that about our body. I think that's what we are supposed to be doing. And part of the tension, I think, I don't know if it was you, Logan, or you, Kai, that said, that there is always going to be sort of, I think, that natural tension there, but lately it's felt like there's more tension. And I want to try to find a way to resolve that.
If it was a comment on conflict, I'm sure it was Logan.
Well,
Chair Heyman, if I can weigh in too, I agree with what's said, and we all have gone through the different meetings and some of the expectations that we walked away with versus some of the results we thought we were heading to didn't kind of line on the same path. But to be a little frank and honest, it's not all just the commission's fault either. I don't want the commission to feel, from my perspective as this functioning as the city planning department, Main Street in particular is awfully sensitive. This is something that has started prior to this tenure that's been a couple of elections with the current council. And the current council, in some form or fashion, came in ready to make some changes in response to previous tensions. Those were functioning under the word density at the time with the Main Street plan and the issues. That density's grown. That density argument grew outside of just the Main Street when we went from the 8 to the 6 units an acre. Some of the housing, you know, that tension kind of expanded outside of Main Street slightly, or quite a bit if you want to look at it. But it also resurged itself back together, particularly the ones work session I think we all remember, where we divided out and we had the open door sign on the land uses, and then it comes to a head to the city council. And I think the council hadn't achieved in their own joint minds what they wanted to do with Main Street. So we solved a density issue and some heights early on in their tenure. It transferred to this whole density discussion for a couple of years. And then all of a sudden it crashes back to the Main Street, the very beginning pain 4 years ago about what's happening there. And I think the council intended well to say, yeah, you're the planners, you should be doing something. And they kind of gave that open door on the use list. But when it came back to their table and they still felt the tensions that the public was giving them, they reared back quick and deliberately and fast. And some of the conversations I had with the council in some uncomfortable moments was they are not giving the clear direction. We're not seeing where they want to head. We're not tools as staff planners as well as citizen planners. And that led to discussions about an outline for lack of better terms, a revamp or replacement of the general plan and the zoning ordinance for Main Street, with a time horizon defined by them for June. And so I think the communication's better. I think that we recognize there's different pages that each group is on. There's some natural tension that's going to be there. It was certainly enhanced when it came back on Main Street. It's such a sensitive issue politically for the public as well as the council. The Main Street plan is generally looked at negatively in a general sense by the citizens, in a very general sense. It's frustrating to the property owners because they feel like the city has never really resolved something was started 4 years ago. And so I think that has led to some of where we're at. You know, weighing the balance of it all, I don't know, but my impression is that after my report to you on the last council meeting and trying to return back to a cooperative effort, they're still unsure where they really want to go. I think they know that they want to do a significant revamp or replacement, but I don't think they understand exactly where they want to land with that revamp and replacement. And so my effort for the next little while to give them an outline in their second meeting in February of how we're going to broach the general plan and Main Street revamp on such a tight time frame. And then I anticipate that we'll define that time frame, and then that time frame will flex in response to how we're going to approach that. And I hope that improves the relationship so that there isn't lingering the communication differences. So I think you've done a good job. I think the council shares in the responsibility in that communication, and I just want you to know that's what I believe. It's not just the commission.
I appreciate that, Corey. You know, after our last meeting, I was chatting with a city council member about this issue, right? What can we do? What can we do to fix this? Because clearly we have a communication problem. And it was suggested to me that maybe part of the issue is because city council, we had this work session early in the year, And then we got direction and we decided, we were excited, I think, as a planning commission, let's run with this table of uses. Great, we can take a small piece and we can make a meaningful change, and this is great. This is a piece we can do. And I think that it fell off of the city council's radar for a long time. And so when it came back up at the end of the year, it was a, whoa, you've done what over the last 6 months? And I don't think that they were really thinking about it.
Right.
So one thing, just to give some consideration to, I've always appreciated our community development director's report and the city council report, where when you always do a great job of giving us a heads up of things that are coming down the pike, right? City council is considering general plan amendment, hey, put that on your radar. And maybe if we're not doing it the vice versa way, if we as a planning commission are doing something, maybe it would be helpful to bring that up in a 90-second briefing to the city council. Hey, just by way of remembrance, planning commission, by way of update, is continuing on in their effort to amend, look at making recommendations to amend the table of uses. They've gone through now 2 public hearing processes, and it's getting, we anticipate that it'll be coming up to you in X.
Yeah.
I don't know, as an
Yeah, I
idea.
think some discussion had taken place at the last council meeting. Councilmember McEwen did bring that up, and the council did approve to have some type of planning commission report on
That's
each
great.
of their meetings.
That's fantastic. I think that what we have now is it's solvable. I mean, I'm an optimist. I'm an eternal optimist, and I think that we can do better. We can do better. The city council can do better, and so I think that communication is a big key. But I sure appreciate your comments, Corey. Anything else? I mean, communication-wise or otherwise, goals that we want to just kind of throw out there to be thinking about, to put on our horizon?
Yeah, I'm open to more joint meetings. I thought it was pretty clear, meaning I thought we got
Yeah,
clear
me
direction on
too.
where to go. It was well communicated, and it just didn't pan out. So I'm pessimistic that communication would improve through more meetings, but I'm open to trying it in my final year as a planning.
Is that really our last year?
I hope so. I really like this actually too much.
Oh.
Yeah.
Okay. Well, thank you guys. Be thinking about it, because we do have this city council work session coming up on February 13th. I think it'll be a good opportunity for us to sort of start exploring what we want to tackle this year.
City council work session.
Isn't it February
It's only
13th,
you
5:30?
Yeah, it's a work session with you guys.
Oh, it's just us?
Just planning commission.
It's not, when,
Right?
Yes, for goals and
That was-
stuff.
The communication side of it.
it was just us.
That wasn't clearly communicated.
It was not clearly communicated. No, you guys are probably right. I guess I've been so excited about trying to meet with the
Yeah.
city council and
But
try
we're
to
still
fix
we're still
this
working out
issue.
the city
Yeah.
council work session.
All right. Well, keep us posted on that, Corey, because I do think, I am anxious to meet with the city council so that we can improve our communication relationship. All right.
We'll get you there.
Thank you guys so much. I really appreciate you and your thoughts. All right, we'll turn time over to staff to give our community development director's report and city council report.
Cassie, we've had a number of applications come in today for the deadline for your next meeting. I'm trying to remember Barris Cove, that's the one on Chase Lane. You have Dual Creek, which is the county's property next to the park in the
The 3 lots.
town area, the 3 lots. Trying to remember,
I don't know if Jeff Cook got his in yet.
the preliminary industrial subdivision, is it preliminary that we're at? Final for the industrial subdivision for the Smith family, and Jeff Cook's been their agent. And I think there's one other item,
Cottage on the corner.
cottage on the corner, conversion it to a plat.
So we have a full schedule next
Yeah.
next
House in the
session.
corner, is that Chad's thing in North Centerville?
That's
Bowling.
Scott Bowling,
Oh,
3rd
3rd
East
and
and
East.
Pages.
the one that's already done?
Yeah.
He's converting, he's
Yeah.
he's doing
He
his,
wants to sell them
subdivision
Oh,
stuff.
It's like for
He-
sale or something.
so he can sell them, convert them to a plat.
So did we say 5:30 at the work session beforehand?
That's,
Yeah, I'm sorry, guys. I'm sure that's exactly what we said, and when it doesn't get on my calendar, it's like it doesn't exist. So, that one I somehow missed putting it into my calendar, and out of sight, out of mind. So,
what I thought at that one is, meeting is I would provide a report in your packet on the past
Yes.
discussions that have occurred. so that you have something in hand to begin to sort out.
That's an excellent idea. Thank you so much.
That's 5:30 on the 13th.
On the 13th. Okay. Anything else?
No?
No?
Council report, if you want that.
Yes, please.
As you're aware, the last meeting you sent up, was it last meeting? You sent up a recommendation on the specific edits to the overlay.
The two, right?
The two. It did go to the city council. The report in the end is they adopted the side yard edit and had a second discussion about whether they were moving on, not moving on, but tabling for further discussion the amendment for the front yard.
Which is the one that we as a body voted to not recommend, right?
Both. The body voted to.
Oh, we voted negative on both.
We gave a protest recommendation, I think, is
I
the best way to
protested the
describe that.
They protested the
Yeah.
protest. So they adopted the one element. They had a significant discussion on the front yard setback and whether to continue that need. I tried to caution them about moving towards a general plan amendment just for that edit, and then turning it right around and doing another general plan revamp to be done by June, and how that can be confusing to everybody that's getting notices. So I tried to highlight that as a little bit of a warning about attempting to do that. I tried to explain potential outs, meaning amendments that the fire station can make with some of the issues that they're still concerned about. And I'm meeting with the chief next Monday about options that I committed to meet with the chief to talk about options. And that was all an attempt to forego moving forward with that other amendment in a general plan. They bought it. So they canceled moving forward with that element for now, and that we can move forward with the revamp and revisit.
And that'll just be part of the larger.
And that'll be a part of the larger discussion. So I think they heard some of, for lack of better terms, your protest. I think the logistics made sense to them. And part of the discussion, I had the impression at least one council member recognized what your message was above and beyond just the specific edits, and opened up the door. I think this was Councilmember McEwen, opened up the door to say, we don't want this to continue, the friction issue to continue. Let's go and get together and work on the revamp and replacement rather than the specific edit. So it seemed a slight healing in the discussion. And so what's required of me is to provide to them on their second meeting in February an outline to accomplish that task. That includes proposing a work session with the Planning Commission. And I'm hoping that we can build that to be a two-part series. The first one addressing and coming to some agreement of how we're going to broach getting this timeline done and how that's going to take place. I finally think I might have had an epiphany of how to put it all together. It took me a long time to figure it out. But I think I have a way. It'll obviously flex and change as we go through the process. And then the other part of the work session with them is after you have your goal setting, send that goal list that you've discussed, ideas, to them, and then have also a discussion part 2 on that goal list as part of that work session. So if you're okay with that, that's kind of how we're trying to broach the matter.
Sounds great. And I have faith in you, Corey, that you can make it work.
Well, I had a lot of doubt until about 2 a.m. this morning. 2 a.m. to 4 a.m. I hashed out an idea.
Thank you very much to both of you. Since we've already had our minutes review and acceptance, we are at the end of our agenda. It ended up being a longer meeting today than I thought. I'll be honest. I thought it was going to be a half-an-hour meeting and we were going to be done. So sorry for the longer meeting. But I move that we adjourn. All those in favor?
Aye.
Aye.